So my task today is to give you a short update on the ongoing preparatory works regarding the entry into force of the Unified Patent Court Agreement. So as you know, this is a project that will completely redesign the patent litigation landscape in Europe. It will have far-reaching consequences, especially in the pharmaceutical sector. So the purpose of today's session is, of course, not to provide you with a full overview of this new system. We would need much more time for that, but only to focus on the latest developments and next steps. So as you know, this project has been delayed many times, especially because of Brexit, then later because of several constitutional complaints in Germany. But despite of these obstacles, the EPO, the UPC Preparatory Committee, and many other stakeholders kept working hard and finally managed to get everything up to speed for the entry into force of the system. So the preparatory work, I will not come back on all what has been accomplished, but in a nutshell, the EPO has adopted implementing measures. The rules of procedure, which are very complex, it's a very long and complex set of rules, have been finally adopted. The new judges that will sit in this new court have been recently selected and are currently being trained. And last but not least, the IT case management system has been finalized very recently. So now, being satisfied that everything was on track for this entry into force, Germany finally ratified the UPC agreement exactly 3 weeks ago. So this is very recent, on the 17th of February. And this ratification will cause the entry into force of the system on the 1st of June. So that means that very concretely, as of the 1st of June, the first cases will be filed before this new court. But before that, we have this sunrise period, which has been provided, a period of 3 months to allow owners of granted European patents and or pending patent applications to opt out from the system. So to understand, so we are right at the start of this period, so this is happening right now, and to understand the importance of this sunrise period, I'll give you a very short refresher on what the Unified Patent Court will be competent for. This is, as you know, an international court common to all the UPCA contracting member states. But its most important feature is that it will not only have jurisdiction on unitary patents, but also on European patent applications, classic European patents, and SPCs, supplementary protection certificates, based on such patents. Unless these patents and these applications and certificates have been opted out. So it's, of course, for that reason that it is now of utmost importance for right owners who do not want to risk a central revocation action or central declaration of non-infringement action before this new court to opt out their rights before the end of May. That's just also a very short reminder. In dark blue on this map, you can see the countries in which this agreement will enter into force on the 1st of June. So very concretely, this means that in the absence of opt-out, it will be possible as of that date, the 1st of June, to have a European patent or SPC revocated in all of these dark blue 17 countries in one single action. So the main features of this opt-out, it will only be possible during the sunrise period or during a transitional period that will follow the entry into force of the system. This transitional period will last between 7 and 14 years. It will not be possible to opt out from the system in case an action has already been brought before the UPC. So that's why it's very important to use the sunrise period, because when the transitional period starts, you run the risk that on day one or in the first days, a central revocation action is launched. So that shows the importance of this sunrise period. There are no fees to opt out. Of course, only European patents or patent applications and SPCs based on such patents can be opted out from the system. Unitary patents and SPCs based on unitary patents will not. It will be impossible to opt them out from the system. Opt-out will also be possible for expired patents, and it will be possible to withdraw the opt-out, but there it's the opposite rule. You cannot withdraw the opt-out anymore if an action is already pending before a national court. Who can opt out? And that's also, it's a bit detailed, but it's very important for the period we are right now. Only patent holders, but if there is co-ownership, this means that all the co-owners need to opt out the patent in all the EPC states. So that's very important because co-owners might not agree on the strategy to follow. So it's very important to get the consent of all the owners. Otherwise, it will be impossible to opt out. Granted SPCs. If an SPC has already been granted based on the European patent concerned, the SPC holder will need to give his consent as well. So important, again, if you don't have that consent, impossible to opt out. And of course, that's I have already said, until the moment the opt-out is in the register, there is the risk, a risk of central revocation or non-infringement action. The opt-out will concern all the states for which the patent has been granted or designated in case of an application. So this means also Switzerland, UK, Spain, or Turkey, for example. So that's important to bear in mind. And a last important point is licensees. Licensees will not be the ones deciding on whether a patent should be opted out or not. So it's very important also as a licensee, in case you have an important patent in license, possibly in exclusive license, of course, the strategy that will be applied to the patent at stake will be of great importance to you. So you should discuss this with the owner. So in summary, very important now, of course, a review of each patent to decide whether or not it should be opted out. And this review should happen both individually, so based on the own merits of the patent, but also in a broader business context, because you might have a strategy where several patents are important to a specific business. You might have divisionals, secondary patents, and there, of course, a strategy could be to opt some of these patents out, probably the most important ones, but still keep one of them or a few of them within the system to have this possibility, of course, to obtain cross-border measures before the UPC against potential infringers. Review both from a claimant and defendant point of view. Of course, this is maybe evident, but as a claimant, the UPC gives you a lot of advantages, but as a defendant, especially in a revocation action, it has also disadvantages. And of course, as I said, there is this possibility to withdraw an opt-out. So a strategy that can be followed and will probably be followed in a number of cases is to first opt out. And at a certain point in time, when you decide that a central action, infringement action, would be efficient against a competitor, then of course you can withdraw the opt-out and launch your action. Provided there is no national action pending in the meantime. What does the opt-out depend on? So what are the decisive criteria? This is a non-exhaustive list. I have already addressed some of them. of course, the balance to be made between the risk of the advantages of central enforcement versus central revocation, individual analysis, patent portfolio, the situation, are there co-owners, licensee, SPC holders, and then speed and cost of procedures. This new court is supposed to be its ambition to be a very efficient procedure, very fast. First instance decisions within 12 months, which is fast, but we have national courts going more or less the same, having more or less the same efficiency. So all these will have to be balanced. Quality and predictability of the decisions. Here again, it's really a question of each of us needs to make up his mind about, or her mind about this, because some say, okay, it will be very, in fact, very predictable because the judges sitting there are very experienced. We know their case law, their national case law, but on the other hand, of course, they will have to discuss their own case law with their colleagues sitting in the same panel, and this might lead to surprising results. With maybe, and that's something to look at, I think, with maybe not always what are now considered the prevailing views, especially of the important patent litigation fora like Germany. I would not be surprised that in some cases it will not always be the German view that will prevail within a panel, but maybe sometimes other views. Risk aversion, of course, it's a bit unknown, all of this, so you might simply prefer to look from the outside and wait and see. And forum shopping, here I will not enter into details because this can become very complicated, but with regard to, there will be forum shopping possibilities before the court, because in a certain number of cases it will be possible to file an action before different divisions of the Unified Patent Court. This might have an influence on the outcome, might depend on maybe diverging case laws that will be developed by the different divisions. But this should decrease over time because, of course, there is one single court of appeal which is supposed to, at a certain point, harmonize these different views. When does the opt-out take effect? If it has been lodged during the sunrise period, so now, and that's the whole purpose and interest of this sunrise period, it will have an effect on day one. So no risk of revocation actions filed before the opt-out. If it's lodged after the sunrise period, it will probably, there is no formal deadline, but it will probably take a few days, the time that the register or the registrar will need to effectively register the opt-out in the system. If corrections are needed, the effect will be as the date of these corrections. And of course, if an action has been started before the UPC, you have this problem that you cannot opt out anymore. And in this case, the opt-out that you would try to make would be simply ineffective. How long does the opt-out last? That's an important one as well. As I said in the beginning, you have this transitional period, which will last between 7 and 14 years. But an opt-out will apply to the patent concerned or the SPC or application concerned for its entire life. So even after the transitional period. And an important conclusion to draw from that is that after the transitional period, no opt-outs anymore. So there, all new rights will enter the UPC system. You will have no choice, and in that point in time, the only way to escape this jurisdiction, the jurisdiction of this new court, will be to file national patents. So that's a debate and a strategy that will probably be followed by a certain number of companies and stakeholders. Where do you have to, how do you file an opt-out? There is, this is a screenshot of the case management system of the UPC, where these opt-outs need to be filed. So it's a bit tricky. There's been a lot of discussion about this case management system because a number of people couldn't access it because it's too well protected. You need a client authentication certificate, an electronic signature certificate. It's a bit complex. I finally made it a few days ago. Normally with the Belgian identity card, it's possible to create an account, but even there, I struggled a little bit. So don't make it the last day. This should be prepared a bit in advance, because without creating this account, which is very secure, it's impossible to file the opt-out. So it's important for companies to identify someone within the company who will be responsible for that. And this person will need personal authentication codes and will have to check that he effectively can, or her can she can effectively access the system. Opt-out and SPCs very shortly. Denis will say much more about SPCs in a moment, but the basic rule is an SPC follows the basic patent for which it has been granted. So if an SPC has already was already granted at the date of opt-out application, then the opt-out will apply to the SPC, but again, the consent of this SPC holder is needed. So otherwise you are blocked and you cannot opt out. And if an SPC has not yet been granted at the time of the opt-out application, then it will be automatic. The later granted SPC will just follow the regime of the main patent. And again, I've already said that, but it will be impossible to opt out an SPC based on a unitary patent. A few EPO transitional measures. So now I'm leaving the sunrise period to enter into another set of measures. These measures have been adopted by the European Patent Office. And in fact, here we are on the other end of the spectrum. So here we are talking about patentees who want to enjoy the new system in full and be sure that they can convert their freshly granted European patent into a unitary patent as soon as the system enters into force. And these transitional measures has been put in place by the EPO for them. They are available since the 1st of January and will be available until the day before the entry into force, so until the 30th of May. Two measures. First, the possibility to file early requests for unitary effects. This measure is only available. In fact, this applies to both measures. These measures are only available for patent applications that are at a late stage. So they are about to be granted. These patent applications have already received 71.3 communication by the EPO, meaning that the EPO has already communicated its intention to grant that patent. So if you are in that situation, it's possible to file an early request for a unitary effect. The idea is that then you file it now during the sunrise period, and the unitary effect will be registered immediately after the start of the system, provided, of course, all formal requirements are met. And the second transitional measure, so a request for a delay of grant of the patent. So this is a measure to be sure that your patent that is currently an application, it has not been granted yet, but you want to make sure that this patent will be eligible for unitary protection. And the background of the measure is that under the applicable EU regulation, it's only possible to obtain a unitary patent for European patents granted on the date or after the date of entry into force. So if you obtain a unitary patent today or next month, it's a bit too early. It will be impossible to obtain unitary effect. So that's the reason why you can then request for a delay of the grant. And of course, it will be possible to combine both measures. So you ask for the delay, so the patent will only be granted a few days after the start of the system, and the unitary effect will also be registered a few days later. So you are sure to have your unitary patent as soon as possible. I will not discuss, I just copied here. Those are two examples that are available on the website of the EPO, just explaining into more details what I just explained. Scenario 1 is an early request for unitary effect, and scenario 2 is a request for a delay in issuing the decision to grant. So it's just an application of what I just said. Once the system enters into force, this unitary patent, and you have already seen this map, but it's an important one. Once you obtain unitary protection, those are the dark blue countries, not all of them, only the dark blue countries. There are 17 countries there in dark blue. This is the territorial scope of this unitary patent. So that's where you can obtain unitary protection. Important to remember is that this is the current state of play. We have 17 EU member states that have ratified the UPCA, but a number of other EU countries have signed it but not yet ratified it. I think the one really in the starting blocks right now is Ireland. They have not yet ratified, but the government has announced that they are willing to ratify that agreement. The only problem they have is that this will require a constitutional change. Therefore, they need to organize a referendum. And they said they would organize this year or at the latest next year. So probably Ireland will be the next one joining. And then we don't know. But what's the impact of that? The impact of that is that you will have several generations of unitary patents. The ones granted in the early stage. So as from the 1st of June of this year, we'll have a scope of 17 countries, but those granted later after the ratification of Ireland or maybe other countries will have a broader scope. Now, a few words about, I've talked about right holders, but of course the right holders are not the only one concerned by this upcoming into force. There is a lot to do also for competitors, potential infringers. One of the things to do is to follow the opt-outs will be made public. There is a website where you can see if several patents have been opted out or not, and this of course can tell things about the patent strategies of your competitors. This possibility to monitor what your competitors are doing is of course especially important if you have identified patents that you might be infringing, in which case it might be interesting to consider filing protective letters to defend yourself against potential provisional measures. This is a system that exists in several states, before national courts at the moment, and this system of protective letters will also be possible before the UPC. Prepare invalidity non-infringement defense. If you have a competitor, there is a problematic patent that becomes unitary, an important feature of this new system is that it will be front-loaded. So that's a very important feature, because it means that, of course, a patentee will have many months to prepare its case, but the defendants will have very strict deadlines to respond to them and will have to raise all relevant arguments very fast. In some cases, it will not be possible to raise arguments which you have not seen in the beginning, and you have not a good reason for not having seen them. So very important. If you see potential problems, you should prepare, because in case there is a litigation, you will not have a lot of time. Other defenses, that's a bit, we will see what that brings, but certainly in the first cases, there are a lot of questions still open, and there will be probably possibilities to raise to test some early stage defenses, certainly in the first cases. Just to give an example, probably, well, maybe you have already heard about that, but the central division of the UPC was supposed to have a seat in London. This will not be the case. All the pharma cases needed to be brought before the central division in London. This is written black on white in the agreement, and it will not be the case. So the first infringement cases, pharma infringement cases, will take place before another division. We still don't really know which one, but that might be raised as an argument by potential defendants. And of course, consider filing central revocation or declaration of non-infringement actions if you think, if you see that a certain patent that might be problematic to you has not been opted out. Yeah, that's just a screenshot of the website of the UPC where you can search for opt-outs. My last slide to end my presentation, just to give you a taste of some of the many questions that are still open for the time being. The one I just mentioned, what about the pharma cases, which is particularly relevant today, of course. Scope of the opt-out, there is discussion. What will be the law applicable to opt-outed patents? Will it be the material provisions of the UPC agreement? Will it be national law? There is discussion about that and several positions, let's say. National torpedoes, there is a lot of discussion also about Article 34 of the treaty of the agreement. I'm not going to enter into those details. But one of the questions is, will it be possible to block, to deprive the UPC of all its jurisdiction, so in the 17 countries, by filing a torpedo in just one jurisdiction? There are many scenarios that can be imagined in that regard. I'm not going to enter into those details, but you have to know this in the early stage of the entry into force. These questions will be of very great importance. Long arm jurisdiction of the UPC. Under certain conditions, the UPC will be able to grant damages for the infringement of European patents outside of Europe. So meaning Switzerland, Turkey, the UK, these countries. So under conditions that are unclear, the conditions of these long-arm jurisdictions are also being discussed for the moment. So just to say, just keep in mind that this possibility exists. Lugano Convention, I'm not entering into the details, but there are also some questions. And then, of course, the last question, and that's my transition with Denis' presentation, will there be a unitary SPC? Will the current system be maintained in parallel or not? Those are the questions that Denis is going to address now.